Thank you very much, commissioners. We take on a new focus on start the session. Members of the press. So we spent quite a bit of time last time. We'll see how the thing goes. I expect we don't need to spend 5 hours again, but all of the commissioners will make a decision what questions they want to ask and also what gaps they thought are there. We'll be focusing more on the law and such areas. And I'll start if you're given the responsibility of selecting a Supreme Court judge, if you are a commissioner today and somebody is sitting in front of you, what attributes would you look for?
Thank you, Madam Chair. Meaning I'm interviewing somebody to be a judge of the Supreme Court.
Yes, that's what you're doing now.
Okay. First and foremost, I'll have to look at the qualifications as per the law. Does he qualify as per the Constitution? That is the first and foremost requirement. Secondly, you look at his experience. You can have the minimum of 15 years experience, but what have you done in between? If you have not been a judge, what have you been doing in the academia? If you have been a practicing advocate, have you been in active practice, or you have just been there counting on your many years of admission? Then I look also, does this person have the drive to go to that Supreme Court and do the work which is supposed to do? Thirdly, we look at other factors: impartiality, independence, competence. Can he actually do this work? So those are some of the parameters. Like for me, I'm a judge. We are political. You don't have to belong to any political wing, so that is a factor. I've never contested any political position, so those are some of the issues maybe somebody can look at.
Okay. Last time when we talked, I remember I asked you about emotional intelligence and actually defined it for us. So today my question is, how would emotional intelligence or lack of it break or make a group? Because now you are working in a group, in a bench. So how would emotional intelligence or lack of it break or make a group?
As human beings, emotional intelligence is part of our attributes. You must have those emotions and you have to have the feelings. Although as an impartial arbiter, your work is not the case does not belong to you, which comes before you. But you are working as a group. When you look at your colleagues, everybody has his own perception about the matter in dispute. So emotional intelligence comes in so that you moderate your emotions so as to fit the views of the others. You don't have now to impose your ego and to impose your feelings so that you become the dominant factor in the group. So if you are the person who pushes for your own self, then you break the group. But if you can calm down and accommodate the others, then the group will work. Furthermore, if you are pushed to the limits and you feel that whatever is being agreed by the majority is contrary to your views, you can have the leader of doing a dissenting opinion. Yes.
Okay. We talk about dominant personality in the group. What other personalities would you expect in this group? The dominant one is the one who has their way, they are really dominant, they want to push their idea. What other personalities and how do you fit in this on the judge?
Thank you. From beginning, I I don't like being seen to be overbearing over others in a group. I like working in a group. I work with low cadre staff. I work with colleague judges. So where I fit is to be a middle ground where you can bend backward, you can bend forward, and if like you are told you as the judge go and write this judgment, that means you'll be given the responsibility, but you will not become the dominant factor in that aspect. If you are told go and proofread this, now you become a lesser factor in the writing of the judgment. So to me, the most important thing is to be a middle person who accommodates the views of all the others instead of either. There are those ones who are laid back. Now we wait for others to say that will not be me. I have now to also at times impose your views so that the others can see what is your opinion about this matter. You don't have to wait and get the view of all the others, then you say, me, I thought, no. At least some form of dominance will have to be there, but you know, now when you go there, you are joining at the tail end. You have now to wait and see how the court has been operating. You can't be a visitor. You are not a visitor, but you are like a visitor who has just come, and now you are telling people, do this, do that. It can't work.
Okay, Judge, when I was preparing for this, I learned about dominant person in the US Supreme Court. And there are some judges who would come, as soon as the dominant will start talking, they go out, and they come when they finish talking. So I don't know whether you've been that person, Judge, how you handle this dominant person, just briefly.
No, I'm a good listener. And that is one tenet of being a judge. You have to be there to listen. And even if the person talking is not in line with your think and thinking, why do you walk out? Why do you walk out? Because walking out is like you're protesting, yet your colleagues. And does it mean that when now you're talking, the others also should walk out? So that does not work. And to me, I will be there even if whatever you are talking is not in agreement, because we have to understand this is the way the judgment in the Supreme Court or Court of Appeal is done. Either it's unanimous or with a few with their own dissenting opinion. So how would you understand what he says if you don't even want to hear it? So me, I will sit, hear everything, and also hear my views.
You're right, Judge. Also, what you sounds like part of the legal intelligence. Lastly, the leader of that court will be the president of the Supreme Court. But even he as a judge will be a leader. So, what leadership will you show in that group? Even though they are not the president of the Supreme Court.
The very fact that you are judge of the Supreme Court exhibits a form of leadership in the judiciary generally, because you are head of the judges of the Court of Appeal, you are head of the judges of the High Court, you are head of the magistrates and cadres. So that in itself is a form of leadership. So coming now to the number, you are 7 of you, you are all equal, you are there by right. So as a leader, what I'll inculcate is that collegiality, that let us work as a team. Last time I was being asked that there is a problem in the Supreme Court. Maybe there is that perception that maybe they're not working as a team, but I will inculcate the feeling that we are colleagues. And what is at hand is the task to be done. So even if you have contrary views to the others, you have to accommodate those views, even if you feel that so and so is not in line with your thinking, because it's the work which brings you together. It's not the friendship, it's not the background, it's not ethnicity, it's just the work. So as a leader, I will try, where there is any disagreement, I'll try to maybe talk to every individual colleague, why are you disagreeing with this, and hear other people's views.
Thank you very much, Judge. I now call upon Acting Chief Justice to continue the questions.
Thank you. My Lord, the Supreme Court Act at Section 3 gives the objectives for which the court was created. Pick any of your choice and discuss it briefly.
Thank you, Madam Acting Chief Justice. There are about 4 objectives of that court. The most important objective is the one of ensuring that the Constitution is supreme. The Supreme Court is there to ensure that the Constitution is respected and it's followed to the letter. How do they do it? They do it through interpretation of that Constitution, enhancing its purpose, its objectives, and its values, so that when a matter comes before the Supreme Court, they have to ensure that the Constitution is followed, and whatever decision they make, it's supposed to be within the parameters of that Constitution, interpret it widely so that it talks to the future, to the present, and you don't limit your interpretation of the Constitution.
Thank you, my Lord. Any case that you have interacted with from the court that has asserted the supremacy of the Constitution?
Since its inception, there are many cases which have come to that court. Maybe I'll give an example of the Murwatetu case. It has some constitutional elements. That is one. And also, instead of, because this one has been talked so much, there is that aspect where the Supreme Court said they struck out Section 14 of the Supreme Court Act, and in their view, that section is contrary to the Constitution, because the jurisdiction is either given by the Constitution or by the statutes. This particular section was giving the Supreme Court the power to review judgments of judges who have either been interdicted by the vetting board or by a tribunal or have retired within 12 months. So the Supreme Court felt that this is unconstitutional. So I think that case is a good example of the Supreme Court trying to live within the parameters of the Constitution.
Thank you, my Lord. The vision of the court, I'll read it out to you, my Lord, is to be a trusted apex court that protects the Constitution, the sovereignty of the people of Kenya, the rule of law, and enhances jurisprudence. It's like 4 aspects of it. Would my Lord please bless my Lord along the vision of the court?
Thank you, Madam Acting CJ. this is one of the objectives for which the court was formed, to enhance jurisprudence and to bear in mind the circumstances we have come from, and to gain the trust of the Kenyans, to ensure that the Constitution is obeyed to the letter, and also the rule of law. So for that court, which has been in existence for 9 years, if I'm to join the court, that is what we'll be doing, because we have also to understand that those cases which reach there, they are quite few. But even if the numbers are few, the judges have also talked in their judgments in ensuring that the Constitution is respected, and they have given advisory opinions in line with the Constitution. There is the opinion on the one-third gender rule. As late as last month, there was an opinion on the BBI, which they declined not to give, so that they respect the Constitution, saying that some of these issues are pending before the court. Even if we can give an opinion, we decline to do so. So for me, that court has lived to the expectation as per the Constitution. So far, I would say they have not failed. They have done their best.
Thank you, my Lord. What has prepared, my Lord, as the seventh judge of the court under that vision? How is my Lord coming to enhance our protection of the supremacy of the Constitution? What my Lord has been doing, or hopes to continue doing, or wants to do to make that court better than it was without, my Lord?
As always, we say there is room for improvement. I believe my background is already in the knowledge of the commissioners. I have been working as a judge for the last 12 years. And if I were to join my brother judges who have been working in the High Court, 2 of them have been there, I will join hands and do what they are doing. I have been doing constitutional petitions, although I've been in the diaspora, but they are also filed there. Malindi, Marsabit, you deal with those constitutional petitions, so you interpret the Constitution in whatever form. Even a criminal case can have a constitutional interpretation. So the wealth of experience I've acquired throughout my almost 29 to 30 years of experience after graduating, I think I will be very resourceful to that court. First and foremost, maybe there used to be backlog at that court, but from what I understand, that backlog seems to have been totally reduced. I don't think there is any issue of backlog before that court. And I will work very hard to ensure that we hear those cases real time as they are filed. If it's an election petition, that one it's controlled by statutory provisions. But if it's any ordinary case, we have to hear it as fast as we can. So mine is I can't say that I will go there with a totally different philosophy compared to those ones who are there, but I will be like an extra cog which is coming to re-energize the engine.
Thank you, my Lord.
Thank you very much, Your Honor. I'll now call upon Honorable Judge Majaja. Honorable Judge Wasame, to continue the questioning. Judge, sorry.
Thank you very much, Madam Chair. Judge, we had a lengthy conversation the last time for the position of Chief Justice. Now you are coming for the position of Judge Supreme Court. What are you looking for in this position you have applied for?
Thank you, Commissioner. I'm looking to serve the wananchi. An opportunity has arisen, and I think I am qualified to join that court, having worked in the High Court for 12 years, and knowing the type of cases which are taken to that court. I think I am suitable to go and be part of the team which is handling these cases before the court. So I'm not saying I'm looking for employment. I'm already an employee of the judiciary. But what I'm trying to look at is to go there and work as a team with my colleagues in the Supreme Court.
Thank you, Judge. And lastly, for me, any one landmark decision rendered by the Supreme Court and which you do not agree with? Only one decision.
Thank you so much. That is a very good question. I've handled election petitions. I've done 2 for governors. I've done 3 or 4 for members of parliament. I have handled 2 appeals from the member of county assembly. I've tried to understand the last decision which nullified the presidential election, and I've read the 2 dissenting opinions of Professor Ojwang and Justice Njoki. It's not that you can say you are totally disagreeing with what decision was rendered, but if you look at, I've read not extensively, but try to understand the logic behind the judgment of Justice Njoki, and I think the nullification was on the ground that I think the transmission of the results was not properly done. The way the election was done was not in line with the law. Everybody has his own views. So this is my own perspective. But I have read the judgment of Judge Njoki, who looked at all those disputed forms. And one of my references which I have provided is the judgment of the governor of Marsabit. Whenever somebody comes and say the voters were turned away in this polling station, you look at the number of registered voters in that polling station and how many voted. So the physical as represented by the relevant form for the presidency from 34 something. So this judge, issues of qualification have to be dealt with by the IEBC. But one of the under the Supreme Court rules, election petition rules number 8, for the presidency, they can equally look at whether that president was qualified. They can also look at whether that president was properly nominated. So if a Form 4 dropout is cleared by the IEBC and vies for the governorship and goes to be a governor, I don't think my hands will be tied to ask him, by the way, did you have this degree certificate? Even if it's at the Supreme Court level, did you have this degree certificate, and how did you get it? To me, I think the court cannot say, since the IBC cleared you, the presumption is that you are a graduate. No, the court can still have a look at those qualifications, because you don't become a driver, even if you know how to drive, but you don't have a driving license, you are not a driver. Thank you.
Thank you very much, Judge, and I wish you well. Thank you, Professor. Chair.
Thank you very much, Judge Wasame. So it's now the time for Judge Majaja to ask his questions. Honorable Judge.
Thank you, Chair. This is, again, we start with you here, and I just want us to continue the conversation briefly. And you recall, I asked you, because jurisdiction is a key issue which, if you look at the Supreme Court decisions, at least a third of them are determined on the issue of jurisdiction. And I asked you, what is the difference in terms of certification between public interest and general public importance. What is the difference? And I remember I asked you that. So has that crystallized now?
Okay. Thank you, Commissioner. You know, some of these things, it's the subjective view of the judges. I remember when you asked me, this thing has been dealt with. I think there is the case of Stein versus Giovanni, where the Supreme Court set up the parameters of what is public interest. And I think there are 3 or 4 parameters which the court came up with, namely the issue at hand should transcend from those litigants and cascade down to public interest, that if it is determined, it will form part of the interest of the public. That's one. Or the issue, the legal issue at hand, if it's determined, that particular legal issue, does it connote some form of public interest if it's determined? And the other issue is that it has it must have been the issue before the trial court or in appeal. So that is public interest. And public importance, it's more or less intertwined with the public interest. But this one now is a general view, maybe not mainly to deal with the legal issues, but the general importance. Does the public want to know what is the view of the Supreme Court on this? So my narrow view about the two, I'm not seeing any big difference, but as I read, even the case of Mitubel, they dealt with the issue of public interest, that since it is an aspect of interest to the public, the court assumes the jurisdiction.
So can you conceive and probably give us an example of a situation where the matter is of public interest, but not of general, remember the word used in the Constitution is general public importance, not public interest, isn't it?
Yes.
So can you tell us a situation where you can have a matter that is of public interest, yet it is not of general public importance for it to be certified? Okay.
I will give the example of Muruatetu. These are people who have been convicted of murder, and that specific aspect is narrowed to those people. But Kenyans also would like to know, although it's not of general public importance, but there is that element of public interest. So for certification, you know, now I cannot say that if it is brought before me, any matter dealing with the issue of gender will be not of public interest. Any issue dealing with the interpretation of the Constitution is of general public importance, because that is the jurisdiction of the Supreme Court. But any issue dealing with a narrow statutory provision may not be of public importance, but can be of public interest. For instance, if there is confusion as to a specific aspect of the law, maybe judges have been giving contradictory judgments, like I cited last time, the issue of wildlife compensation. Do you start from the committee at the district level, or do you can go to court direct? That matter is of general public importance, because those who are attacked by wildlife, they would like to know: can I just go to the court, or can I go to the tribunal? So that is a matter of public importance. It's important for whoever is a victim to know where to start from, but it doesn't have that legal aspect in itself.
Okay. In one of your writings, in one of the sample writings you submitted, this is a case of Mercy Kingo and Safaricom. This is an issue that has concerns artists. and their disputes with collection societies. And in that case, it was an issue where the Safaricom and other providers were required to pay to the collection society so that the artists can be paid. That was the case, isn't it?
Yeah.
And you declared a provision of the Copyright Act unconstitutional because it violated the petitioner's freedom of association. You said it's her money, she has earned it, and she should be paid directly. That's correct, eh?
Not paid directly.
Yes.
The issue in dispute was they already had existing collectors.
Yes.
They had already entered into an agreement with some
other collectors. Okay.
So the law came in with a requirement that now you have to go to
a specific collector. Now, so having held that collector, the statutory collector, the one approved by statute, that law was unconstitutional. I want you to tell us how a statutory collecting society, because a collecting society is internationally recognized in copyright protection, how that limitation can be justified under Article 24 of the Constitution, the existence of a statutory permitted collection society. How can it be justified?
Okay, maybe the background to that case is that
I'm now
yes.
I've moved from the case. I've moved from the case. I'm now asking, how do you justify a statutory approved collection society to which artists money is paid? Because if it is a violation of if you assume it is a violation of rights, then the state has to justify. So I want you to tell me under Article 24 how we justify that violation.
Okay, rights can be limited, but the way you limit it, it also has to be justified that because of ABCD, we are limiting your freedom of movement the same way we have the COVID pandemic. Your freedom of movement is limited to these particular hours. So for this copyright, the statutory provisions already, okay, I know you don't want to look at the case, but already those ones who are collecting were also provided by the statute. So there were two different statutory collectors. The artist had a right to, because you are many, you go and sign an agreement with the collector A. And this is the Dunda tunes, I think, where if the mobile rings, somebody is talking, so maybe the musician is singing. So already I have my collector. You are limiting my right to have that collector. You are now imposing another collector. If you read the law, this was a new introduction. And they were saying there was no public participation. I know Justice Mumbi Ngugi had dealt with the matter and declared that section not unconstitutional, but my view, the way the matter came was that you are now being forced that instead of using your existing collector, go to this. And to me, I thought that these are just another way of limiting this.
So I want you to tell me how it can be justified. How it can be justified.
It can be justified maybe just to say for purposes of formalities, so that all of you are put in one section, one collector, or a specific number of collectors. Maybe these people, the way they will be taxed, the way taxes will be collected, we think that all these musicians should use this. There could be some parameters of limitation like tax collection, maybe compliance with the statutory provisions. These are the collectors who have been licensed. Maybe if you are many, there will be a problem of compliance. So to some extent, it can be limited.
Okay. Next question. The Supreme Court plays a very important role in devolution, and that is one of the key areas of jurisdiction of the Supreme Court. Can you tell us, identify any two pillars of devolution in the Constitution and why you think they are important?
Okay. The first pillar of devolution is the right to govern yourselves, so that those who felt that they were marginalized can now say that we are running our own affairs. So that is one aspect of devolution, and it has some historical connotation. The other pillar is the distribution of our finances and the economy. So the distribution of wealth to cascade down to the world level is part of the devolution objective.
Okay, so having identified those two pillars, how has the Supreme Court supported those two pillars? And you can cite specific cases. And
there is the case of the Speaker of the Senate and others versus the National Assembly, where the Supreme Court was called upon to decide whether the Senate has an input in the division of revenue bill, which had been passed by Parliament. And the Supreme Court said yes. It's not that the Senate should wait for the division of finances amongst the counties, but it also has an input in the division of revenue bill. I think that is one aspect I can look at and say maybe that is the only case I can say.
Okay.
Yes.
Finally, international treaties, and we agree, international law is part of the law of Kenya. International treaties play an important role in protection of fundamental rights and freedoms. Can you tell us any African treaty that is applicable in Kenya that is important in terms of underpinning this Bill of Rights?
Okay, we have the African Charter for People and Human Rights, which was Kenya is part of it. So that one follows the International Covenant on Civil and Political Rights to some extent, but I think that the African Charter of People and Human Rights has some connotation of.
Okay.
Yes.
And what is the enforcement mechanism of that treaty? Briefly explain to us.
Okay, these treaties, states are called upon to comply with the provisions of those treaties, and the enforcement mechanism is by periodically reporting periodically reporting if you have assented to the treaty, so that you file periodic reports, just like the UN, you have to file your report on human rights, other civil liberties. So there are those periodic reports the state through in Kenya, the Office of the Attorney General. They file these yearly, either yearly or biannually. I am not so sure about that, but there are those reports. But there is also the court, like we have the court in Arusha. If in case there is anybody complaining, then that dispute can as well be another way of enforcing the law.
Any case of note concerning Kenya?
For Africa, I would look at the one which dealt with the decision of Honorable Martha Wangari, and then there is the one of those people who live in the forest, who went to that court, and Kenya was told that you have to leave, you have violated their rights.
Okay, thank you very much, and thank you, Chair.
Thank you very much, Honorable Judge Majaja. Thank you, Your Honor. I'll now request Commissioner Macharia Jero to ask his questions. Commissioner.
Thank you, Chair. My Lord, just a few questions in view of the fact that we interacted more comprehensively in the last interview. Now, the first question. Next year we'll have an election, presidential election, and of course, if there's any matter to be decided regarding the election, it has to be at the Supreme Court, where you would be if you go there and become a judge. Now, we are all alive to the fact that there's that tendency of the general madness that engulfs our country every time there's an election. Now, which leads me to the question, as judges in the Supreme Court, you being one of them, what do you think it would take not to be influenced by external factors, the prejudices, where everybody, you'll see that everybody becomes affiliated to a certain political thought. You are supporting a certain cause which could end up now influencing even the way one is taking a position in the Supreme Court, where you find that rather than providing guidance that is purely, dealt with in terms of the law, facts, evidence, there are also that prejudice that could also come in among the judges, when sometimes they bring in divisions even amongst them. Now, I'm not saying that has happened before, but I'm just putting that as a scenario. What is it that you would say it would take for judges to decide a matter, devoid of all these external influences?
The determination of a presidential election petition is a constitutional requirement under Article 140. So, not even an election petition. Every case, most of the cases have some external factors, external push. There are those for and there are those against. So, as an impartial arbiter, you are not saying you block your ears, but it's presumed that you are not hearing those factors. You are living in the community. You can open your WhatsApp, so and so is saying this, another one is saying that. But when it comes now to hearing and determining that case, what will be at play will be the documentation presented before the court. Note the stories you read in the newspapers. Note the views of people you are watching on the television. So even if people, the judges, there everybody has his own opinion, not because he's a supporter of a certain political party, but it's because of his or her understanding of the case. So I don't think there is room to be influenced by external factors. We are there to dispense justice, and we will evaluate the case and do justice to that case.
Now, then, when it comes to the issue of external influences, now let's forget about the presidential election matters. Even in general disputes that would come there, where you could find that there are prejudices, maybe because of the way we've been brought up, probably because there are certain beliefs that one has, how do you marry that with when a matter comes where there could also be different positions that are taken by the different judges you'll be with in the same court? How do you marry that and ensure that at the end of the day, whatever ultimately is the basis on which a case is decided is not on these prejudices of the different judges who could be in the court?
That is in line with what Madam Chair, Commissioner asked, that now that you are there as a judge, how will you assist in handling some of those cases? You know, now you are putting me in a position where I can say so and so is prejudiced or biased towards this, but I don't think that would happen. If I'm there, all what you need to do is you have taken an oath to dispense justice. So dispensing justice means you are impartial and non-partisan. Being a judge of the Supreme Court, where the responsibility is much higher because the task at hand when it comes maybe to the presidential election or to even any matter which reaches that court, I would say that negotiation and trying to reach a unanimous decision without infringing on the views of others will be maybe the most important thing to do, at least to try to harmonize. But if somebody is of a contrary view, what is his position and why does he have that position? 1. 2, will also be guided by precedents. We have had several cases before that court, and we will see what the court has said in the past and try, although the court is not bound by its past decision, but we can see those cases as guiding aspects of determining future cases.
Mm. Now, the other thing is about the development of jurisprudence. Because you see, we are a country also, I think, based also on our training at the university and the law school. We have this tendency of relying heavily on common law. And of course, this common law, as we know it, was developed elsewhere. These are traditions and practices of another country. United Kingdom to be specific. Now again, when you come now to Supreme Court, you'll see that one of your requirements is so to develop our own jurisprudence, guided by our own traditions, our own practices, our unique circumstances. Now, I'm not sure whether that the Supreme Court has been able to realize so far. The jury is still out there. I'm not saying that they've not. But what role would you play in ensuring that even as we develop that jurisprudence, not that we'll ignore what has been decided elsewhere, we are, as legal practitioners, we are very good at quoting decisions from other jurisdictions. But what steps would you take, of course, in a collegial manner, to ensure that we have this jurisprudence in accordance with the expectations of the law that is also suitable to our circumstances, not relying on jurisprudence and circumstances of other jurisdictions?
Thank you, Commissioner. It's very rare to get a legal issue which has never been tackled in this world, that this is quite unique. Even if a case of COVID is filed today, it must have been filed elsewhere and a judgment or ruling rendered by another court. So we cannot operate like we're an island. So even the jurisprudence which we want to develop within our country, I'll give an example of the declaration that the mandatory death sentence is unconstitutional. If you read the Murwatetu case, the court elaborated other similar circumstances in Uganda, in other countries. So although we want to say we want to have a homebrewed jurisdiction, but to some extent you'll have to see what others have said. So if we are there as judges of the Supreme Court, it has been there for less than 10 years. When you talk of Marbury versus Madison, this is a case which is over 200 years old. So you cannot say that within 10 years we can pick and say this is the Supreme Court jurisprudence which has been developed within time. The common law we are talking about, how old is the common law? Many years. So my view is we have to give that court time. And the jury out there is, we want quick fix. So how do you develop jurisprudence within a short time? Jurisprudence is something which grows slowly as the cases emerge. And as they are developing the jurisprudence, there will be criticism. Maybe they will feel that the criticism is well-intentioned and veer towards another legal line. So by the time the court finds its direction, maybe it's 20 years. So let us give the court time. We are in a hurry to judge them. Or these judges, where is the jurisprudence? But the cases which have been taken there, they have handled them. They have given advisory opinions which have been useful to this country. They have handled 3 election petitions which form part of our jurisprudence. For instance, the standard of proof in election petitions. Although they came in with these not below balance of probability or not equal to beyond reasonable doubt, but that aspect has also been dealt with by other courts in India and other jurisdictions. So to develop your own homemade jurisdiction and say this is unique to Kenya, it will take time.
Okay. Now my last question, this is now nothing to do with the jurisprudence, is that there's no doubt, I must say, that you write very well. When you look at your decisions, very well researched, they've captured the legal authorities, the facts, evidence, and you're also bold. You've made decisions without fearing the criticism and all that, and you think well. Good material for Supreme Court. But now then the question would be that probably somebody would say that you need to wait a little bit longer. You are young, you give chances to others who have been there a little bit longer, probably move to the next level, Court of Appeal, and develop more jurisprudence, then before you can take you to the Supreme Court. I don't know what would be your response to that, in terms of, when you balance yourself. We are now dealing with practical issues here. Sometimes the commission, we must also be practical about dealing with the various, when we retreat to make those decisions of who we give, sometimes we look beyond that very sharp judge who is able to make very good decisions, but we say, agoje kidogo labda tutaangalia maneno yake baadaye. I don't know what you would say about that. Thank you, Chair.
Okay, thank you, Commissioner. Now it goes back to the qualification. Have you done 15 years? Yes, I've done. Even the CJ can go there with, we can get a Chief Justice who is hardly 50. And because he graduated when he was 25, and he did 20 years of practice, he's 45, and he becomes a CJ. He comes here and impresses you. Won't you give him that position because of age? In fact, that will be discrimination if we are to follow the Constitution. That will be discrimination in form of age. Be that as it may, in America, they have 9 Supreme Court judges. I think there is one who is 48 years below my age. There is another one, I think, if my memory serves me well, called Neil Goodrich, something like that, who was born in 1967, like me. There is another one who is around 55. And then we have the old ones who are 82. Justice Clarence Thomas, I remember him when he was appointed, when he was serving. I had a lecturer from America, Justice Clarence Thomas, he used to be his critic. He's 72. So it's a blend. You can't say ngoja kidogo because you are 54. We will look at you when you reach 60. I have a classmate in the Supreme Court, and he has been there for 5 years.
very well said with those examples, Honorable Judge. And I even thought, even in Kenya, Commissioner, we had a very young judge. Was it in the early years? Yes. It's now my honor to request the Attorney General, Commissioner Kariuki, to ask his questions.
Thank you, Madam Chair. Good morning again, Judge.
Good morning, Attorney General, Commissioner.
Let's just follow up on that last question of Honorable Commissioner Macharia. And you mentioned the U.S., and you're well aware of the contribution of the late Lady Justice Ruth Ginsburg. What special attribute, my Lord, particularly in terms of judicial philosophy, would you be bringing to the Supreme Court so as to shape its future?
Thank you, Commissioner. As judges are appointed to a court, most of them maybe have been having a certain aspect of saying, I'm aligned to women's rights, like the judge you are referring to, women's rights, civil liberties, and so forth. There are those ones who have a bias to criminal law and would like to deal with issues, to deal with the criminal justice system. So for me, for the specific question for me, my jurisprudence will be based on the rule of law. Let the law be the supreme. Let the Constitution be interpreted widely so that it encompasses the rights as provided under the Bill of Rights. Let us not restrict the enjoyment of those rights as aspired by Kenyans. So the philosophy and jurisprudence on the aspect of constitutional law will be to ensure that rights should not be limited. I'll give an example. When I was in Malindi, there was a curfew which had served its purpose because of terror attacks there, and a petition was filed, and I think I declared the curfew to be not serving the purpose, and people want that freedom. We came from very far, so the fishermen cannot go to the sea because of this fear. Terrorist attacks, and now you limit yourself because of fearing him. So I felt that this is too much. Almost 6 months down the line, people of Lamu cannot go about their lives. I remember handling a murder case of a police officer who was manning a roadblock, and it was just 6, and a boda passed very fast, and a lady who was the pillion passenger fell down and suffered brain damage, and she died. So with that in mind, is the curfew necessary after 6 months, like the case of Lamu? So my philosophy is let us give the freedom to Kenyans. Let them enjoy the freedom as enshrined in the Constitution. Let us not put so many limitations, a lot of gabions and bottlenecks to Kenyans. Where the limitation is due and there is a good reason for that, I would uphold it. But my philosophy is that Kenyans want this freedom of all the rights as provided in the Constitution, and if I'm there, I will strive to enhance that.
Thank you very much, my Lord. Let's move on to another aspect of collegiality. Would you agree that collegiality is particularly important in the Supreme Court? And if so, why?
First and foremost, I do agree that collegiality is very important. Why? Because it gives trust, that you trust the person seated either on your left or on your right. You are seated there as colleagues and you are doing the same work. All of you are there with the authority of Kenyans. So without collegiality, where you can stab your colleague at the back the moment he leaves, or you can rubbish whatever ruling he has written and say, Sasa huyu, what has he written? That I think damages the trust the Kenyans would have given to the judges. So collegiality is quite crucial in such a court. First and foremost, you have few. Unlike in the High Court where we are almost 100, the law provides that we can be 200. You may not have that close link to a colleague, but if you are 7, you are seated in the same area, going to court in a batch of 5, or even all of you 7, I think there is that need to know one another, to move together. It's a team. I would say it's like a netball team where you're a team of 7. So it's important, Commissioner, that the judges of the Supreme Court should embrace collegiality. You can have contrary views. Collegiality does not mean that all the judgments must be by unanimous decision. But even when you are disagreeing, you also respect those of contrary views, and without any finger pointing or shouting at each other, so that tomorrow, I've seen, like in the Supreme Court, I've seen one judge, like I've seen in the case of Rai, Justice Ibrahim dissenting. I've seen in another case, Justice Njoki and Ojwang dissenting. So I've seen Justice Lenaola dissenting, but so long as there is that collegiality, tomorrow will be called in another case and we have to handle it. So it's quite important.
Thank you, Judge. And how would you then balance in maintaining that collegiality on the one hand and the decisional independence of you as a judge of that court? How would you balance those two concepts?
Thank you, Commissioner. The balancing comes in many aspects. First and foremost, don't have a fixed mind that I've read the file and this is my position. If you say that and the other 6 also say that, whose position will be paramount? So there is that need of giving way and relooking into your position, also relooking into each other's positions, so that by the end of the day, you also understand where the others stand. Then that independence, because there is that aspect of not being influenced by colleagues, so that you can be independent. That's why now the dissenting opinion comes in when you think that, to me, this matter, the legal position, I've read other jurisdiction, I've read the past decision, maybe from the High Court, which are convincing. Then you come up with your own decision, so that you don't just agree for the sake of saying it's a unanimous decision. There is that room for disagreement. So there is the need to balance where maybe there is doubt in your mind whether your position is the correct one, you can give in. But when your competencies and experience makes you to conclude that your position is the correct one, you stand by your position.
Thank you very much, my Lord. Finally, you've just used the word trust, and this came up earlier in the context of the vision of the court. The need for the public, for Kenyans to have faith and trust in the Supreme Court and indeed in the judiciary. Now, my Lord, in successive reports of Transparency International, the judiciary has been ranked as the most bribery-prone institution. Now, in that context, and with a view to enhancing the trust that the general public have in the Supreme Court, how would you, as a member of that court, seek to remedy that perception that the court is prone to bribery?
Thank you, Commissioner. The work of the judiciary, I don't think there will come a time when a survey will be done and Kenya say there is zero corruption in the judiciary. Why do I say that? It is because of the nature of the work. You deal with people's lives, the interests are so high, and the expectations from the public is also quite high. So, Transparency International, whatever they do, we cannot fault it. It is correct. Even the reports, we have had the Ringera reports, we have had the UCO reports, the aspect of corruption is also, we have had your report, we have had the aspect of corruption is there in the judiciary. So to be specific to the Supreme Court, I've not seen that report as given in relation to the Supreme Court what the percentages are. But if I were to be there, how to enhance the trust? First and foremost, to me, the moment a case delays, it raises suspicion. That is my main focus on this corruption. Because I don't think there is a case of a file not found in the Supreme Court. The delay in the Supreme Court is also not very much. But for me to enhance the trust is to ensure that we deliver justice as fast as possible. The Supreme Court is also meant to, one of the objectives is access to justice, to ensure that whatever justice is being cooked in the court is to some extent in line with people's expectation. I know we are the experts who will be interpreting the Constitution, but we don't have to interpret it in such a way that even a layman will say, surely, well, this judge is bribed, or this was the correct way. So it calls for enhancing our competencies, understanding the expectations of the wananchi, transparency within the determination of the cases, and giving good reasons for what we do, so that people can reduce. I would say reduce. You cannot eliminate perception of corruption, and we cannot say that so and so is corrupt. If you are called upon and go to testify, you can't. So some of those aspects of corruption, the only way to me I can deal with is to clear any case which comes within a given time frame, well reasoned. Here you are. The winner will be happy. The loser will say, I think the judges were corrupted, but we cannot eliminate that.
Thank you very much, my Lord, for answering those questions. That will be all from me, Honourable Chair. Thank you.
Thank you, Commissioner.
Thank you very much, Honourable Attorney General. Judge, did you say that there's no survey which will be done to show zero corruption?
I can bet to my last penny there will be no survey whereby you go to a court in Nakuru, zero corruption, you go to Kisumu, zero corruption, you come to Court of Appeal, zero corruption, and we come here and say, JSC, hallelujah, there is zero corruption in the judiciary. It will never.
Okay. That's a bit sad, because I was hoping maybe even if it takes a few years, we could one day say that. But thank you, Judge. I now call upon Honorable Gishohi to ask his questions. Commissioner.
Thank you, Chair. Judge, good morning again.
Good morning, Commissioner.
Now, I want us to focus on the role of a state officer. And I'm sure you are aware that as a judge of the Supreme Court, you are a state officer, and you are bound by Article 10 of the Constitution as the national values and principles of governance. National values and principles of governance that bind all state officers. Would you pick two of those principles and share with the Commission how you are going to promote them as a judge of the Supreme Court? Just two of those principles under Article 10 specifically. Two.
Okay, the first one will be to ensure that your public interest prevails as opposed to your personal interest. So the position of a judge is one of trust, as the Commissioner IG has said. When you are given this responsibility, your duty is to serve, not to serve the Wananchi, not to enrich yourself because you are there.
Let's focus, Judge, to Article 10 specifically. Yes. If you look at that article, those principles of governance are very, very clear. And I can give you an example. One of it is patriotism, national unity.
Yes.
Just share with us how you promote those national values and principles as a state officer, as a judge of the Supreme Court.
Okay, because most of them now are enhanced in the Code of Conduct, they are enhanced in the Leadership and Integrity Act, but let us come to patriotism.
Patriotism, yes.
Yes. So as a judge, you have to be patriotic. You sing the National Assembly, you sow allegiance to the Constitution and promise to do what you are supposed to do. That aspect of patriotism is paramount, because you have now to know that Kenya comes first as a country and not you as an individual. You have to serve the Wananchi. Kenya means the people of Kenya, what they expect of you. And the patriotism comes in many aspects. If I'm there and I'm not working, yet I've been told to serve the Wananchi, am I patriotic? I am not. So it means I have to work hard and meet the expectations of the Wananchi. Another aspect of patriotism comes in the work we do. If there is any dispute between Kenya and any other country, we have to be objective and see what are the interests of the country.
Okay.
Yes.
Let us reflect on that ruling you had for Lamu.
Yes.
About the curfew and all those other issues.
Yes.
What did you say about that, in that spirit of patriotism as per Article 10, without prejudice to whatever you say?
I understand you. You know, patriotism also means that you have also to respect the rights of the Kenyans. I was living in Malindi. People were traveling from Malindi to Lamu. If you reach in Peketone at 6, you are stopped. You have to sleep in the bus. There is no imminent danger. The danger had already been dealt with. So when it comes to patriotism, here it's true. The Minister for Internal Affairs has declared a curfew from 6 to 6. The law, it provides for a certain duration, so it has been enhanced. After the period expires, it is enhanced. There is no public participation to see you people, are you happy or what? They are complaining every day. They are complaining. So with patriotism, we feel that I am not going to be patriotic just to be with the government and say, you people, even if you are dying of hunger, just stay inside because we want to fight terrorism. No. Patriotism comes in. These Kenyans need to work and earn a living. So let you can have security even without the curfew, because you can put the security personnel in the streets.
Okay.
Yes.
Okay, that's enough. We got something else. As you go to the Supreme Court, I'm sure there are committees that you might be heading or you might be a member, and there will be public finance that will be affiliated to you. In terms of Article 201 on management of public finance, there are two items there as you manage public finance. One is financial management shall be responsible with the physical reporting regularly. As the chair of one of those committees in the Supreme Court, what is your understanding of that statement under that Article 201? Financial management, responsible use of the money.
Thank you, Commissioner. If I'm to be a chair of a committee, maybe I don't know. I have not been there to know what committees are there. Maybe human resource or finance or any other committee. It entails the use of money. The money we utilize is from taxes of Kenyans. So as we use it, the record has to be there how it has been used, and a report has to be made each financial year. If per diems were paid, who was paid and for what purpose. If somebody was sent out of the country and was given some imprest, how did he deal with that? If we are procuring, like maybe some judges need vehicles, it will go through the CRJ, but maybe the committee will deliberate. Do you just say, because I'm in the Supreme Court, I need a V8 instead of the ordinary car? So there should be that responsibility that you are not here to enrich yourself or to make yourself so comfortable to the expense of the taxpayers. And in other words, accountability. You have to account for the funds you have been given, and proper utilization of resources is a requirement.
Okay. Thank you, Chair. Thank you, Judge.
Thank you very much, Commissioner Gishohi. It's now the time for Commissioner Koskei to ask his questions. Commissioner.
Thank you, Chair. Good morning, Judge.
Good morning, Commissioner.
Yes, I have two questions, and one is on Supreme Court and the advantage is that you are an insider in judiciary. So looking at Supreme Court as it is now, what new things do you think needs to be introduced so that it can serve this nation efficiently and effectively? People talk about issues of structure. Can it be expanded? Can it be transformed to approach its function in different ways? To you, as an incoming Supreme Court judge, what do you think are new things that needs to be introduced for it to serve this country better?
Thank you, Commissioner. In form of numbers, I think the numbers are sufficient because the law allows them to sit in a batch of 7. In form of competencies, I think the requirement is enough so that you are not told if you put it at 20 years, people will say you want to exclude others. What needs to be done? I think I can't say it's 100% perfect. Okay, I think this is just my view, how you think can be done. Okay, in my personal view, I think if a judge is appointed to the Supreme Court, a maximum of 15 years should be sufficient so that we can clear you. I know other jurisdiction you are judged for life in the Supreme Court, but think we should be alive to the fact that if I'm there and I have a specific stand on something for 20 years, for 30 years, I'm there as a judge of the Supreme Court. I think we need to look into this aspect of being there for 25 years. A High Court judge, it's understandable, but I think we should come up with an idea of a maximum of 15 years. In any case, when you go there, you are 50 plus, 15 years will be 65, which means the minimum retirement, the voluntary retirement of a judge. So maybe JSC can look at that so that I'm not appointed at 54. I go there, I block others from coming. I'm just there. This election petition come. My policy is the same. No election petition should be allowed. I dismiss another. So you hear around 20 election petitions, and even those coming to you now fear that the same way people were fearing going to the Court of Appeal will be the same issue because a judge has sat there, and we know his philosophy. At least there should be that change of ideas, change of personnel. I think that will be my view.
Any other, or that is what comes over your head now?
Any other, maybe we have been talking of individual judgments because the work there is not much. Maybe when it comes into the same issue of a matter of public importance, we might want to know what is the view of each and every judge. Maybe we can come up with the rules. So long as the court says this is a matter of public importance, you can discuss, but let each and every one of you come with his own judgment. And you can zero it even to election petition that each one of you should write. You can conference and each one of you write his own or her own judgment so that we can know the views of each and every judge.
Thank you, Judge. My second question is, you've heard this saying, necessity is the mother of invention. Now, let us talk about COVID-19 pandemic and judiciary. What challenges has this pandemic brought into judiciary operations, and what are the opportunities that has this pandemic availed to transform the way judiciary operates? Could you give us perhaps 2-3 challenges and also opportunities that you see this pandemic has availed to this country?
Starting with challenges, Commissioner, judiciary all along, it's an interpersonal aspect of decision making. A witness comes, he talks. As he talks, I can make an impression. Is he telling me the truth, or is to some extent lying, or is not so sure? So that aspect of open court has been affected. So that is one challenge. Another challenge is also judiciary does not operate on its own. There are other criminal justice sectors like the prison. I remember when I was in Marsabit, the head of prison get instructions from Nairobi that no prisoner should go to court. So what do? This is a person who has been charged with murder. He's at the police station. He cannot be taken to the prison because the prison is not admitting anybody for fear of spreading COVID in prison, for good reason. But now the police station cannot feed this person. He has been brought all the way from North Hall, which is over 300 kilometers from Marsabit. The relatives are not there. Who buys them food? So those are the challenges which COVID has brought in. Then this challenge also has generated into creating backlog. Cases are not being heard. Most of the judges are in their 50s. We are told whoever is 58 and above can work from home. We have people with pre-existing conditions. They cannot come because the fear of getting COVID, and it's real. Courts have been closed because staff have COVID. And for you not to spread it further, you close the court. Commissioner here has done good work because there is no alternative. You have to close the court. So those are the challenges which COVID-19 has brought. And what has been the avenue, we have seen an opportunity to improve our connectivity and internet connectivity and the use of technology has really come in handy. There is the challenge of finances because we were not prepared. The system had to be upgraded. It's a challenge also, though it's an opportunity, but it's a challenge. If you log in at Milimani at 9 and all the judges are using the system, there'll be ups and downs. Sometimes you can't hear the other person on the other end, but it has served. So far it has served. In my view, it's an opportunity also to hear matters which do not need physical attendance, like appeals. An appeal is filed, the record of appeal is filed, you are not taking any new evidence. You can hear these appeals online, especially those ones where there are advocates involved. At Milimani, there's been a very good device, which I like it for those who don't have lawyers. If you don't have an advocate, there is a place where you can go there, you are connected, your case is there, you are representing yourself, you are logged in, and I can see him that this is so-and-so who has come for his case, and then he can talk and he has that comfort of the staff. So I think we have also tried to assist Kenyans despite the challenges we have.
Thank you, Judge. My final question is on involvement in community service. The other time we discussed, and you told us that you involve a lot in schools, mentorship, many other things. But when I was going through your CV again, I realized that you are doing PhD in Peace and Conflict Studies in Masinde Muliro University, and you are currently writing a proposal on radicalization. What have you in any way tried to, work with the community to see into it that this radicalization is sorted, especially in Kwale, where you come from, and Mombasa, as community service?
Thank you, Commissioner. Actually, I've passed the proposal stage. I've submitted my findings, and now they are with the external examiner. So I'm waiting for the feedback. Then I do the second defense, and I will be ready to graduate, God willing, the course of the year. Community service is an important aspect, and it's good you have raised that issue. I come from Kwale, and with radicalization, community service, you have to do it in a very indirect way, through empowering the youth, and also through education. Kwale is one of the most affected counties when it comes to radicalization. Why I picked that topic, there are many returnees from Somalia in the county, very many. These are people who are trained. There are people who can't build a house in their rural home because for fear of being attacked by the returnees who feel that they are being haunted. Coming back to the question of community involvement, I've engaged the leaders in that area, the MCAs, to try to talk to them. During my research, I attended several meetings. One of them being preparation. Each county is supposed to come up with a county action plan to fight radicalization. So I remember being invited to go and being a participant and talk about radicalization in the sense that we have to how to eliminate it, because it's deep-rooted, and you cannot just like corruption say there is no radicalization. This is somebody with his own ideology. So I have participated in trying to fight this menace. I've talked to several NGOs. There are so many NGOs in Kwale and Mombasa which deal with this aspect. Muhuri, there is Aki Africa, who have done very commendable work. And I have engaged the ATPU in Mombasa, not in Nairobi. They have good intentions, trying to talk to the Wananchi coming. I've talked to the religious leaders, trying to see how they, even there is that fear. I've been talking to Qadis who are judicial officers, and they are saying, Saidi, if I go to the mosque and talk about radicalization, I'll be killed. But I've tried to talk to them and say, you don't have to denounce it publicly, but where you can, and you can go and talk to family members that there is suspicion so and so is engaged in this thing. Can you talk to him? And they have understood me. So it's a dangerous aspect where village men, in fact, in that meeting where I attended, the county commissioner told me nobody is coming forward in some areas to be a Nyumba Kumi elder. Nobody. It's there, but nobody is coming forward for fear of being eliminated. So I've tried my level best, and I've understood the problem. So prison is doing very good work trying to reform them. But now you can go to certain extent. If you poke your nose so much, you can also be eliminated.
Yeah. Thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Honorable Judge, out of interest, what methodology are you using to collect data? Is it qualitative or quantitative? Yes.
I have structured questionnaires. Some are in English, some are in Kiswahili, because of maybe I've been targeting the imams and the religious leaders and the community. Then there are those educated ones, the NGOs and whatever. So that is one aspect of data collection. I have also interpersonal interviews, which I've done at ATPU, I've done at the prison, I've done with the CEOs of some human rights groups. Those are the main. The other aspect of maybe secondary material reading is also there, but I've been using questionnaires and personal interviews.
Good, and also maybe focused group discussions.
Yes. I had about 3 focus. I had a focus group at the Mombasa Law Court twice with Judge Ogola and about 6 other magistrates and a few legal staff. I got the permission from the chief registrar to go and collect the data. In fact, I had 3. I had another one at Shanzu Law Courts and another one at the Qadis Court. In fact, the Qadis Court, it was an open, their conditions, at least 8 people. So I was there with the Qadis, 3 Qadis and the staff there, and I had another focus groups with the community. With the community, yes. FDG, you call them FDGs.
Okay, thank you very much, Judge. Commissioner Onwende, it's your time to please ask questions.
Thank you very much, Chair. Judge, there is a statement you made earlier that is making me rather uncomfortable. I just want to be clear. The Chair also revisited it and you still maintained your position concerning corruption. You said that there can never be a day where we will be zero rated for corruption. And I'm thinking it is important because there are people out there listening to you, and you are a person who speaks with authority when you speak about the judiciary. It is important to draw the distinction. Are you talking about corruption generally, or are you talking about the perception of corruption?
Thank you, Commissioner. Maybe I misunderstood. I'm not saying that the judiciary staff will be corrupt until Jesus comes. No, that is not what I'm saying. What I'm saying is, you know, when the survey is done, it covers both it mainly covers perception that because this is somebody's opinion. What do you think about the judiciary? Is it corrupt or it's clean? So what I'm saying is there will not come a time when you can go around because this is a survey. You won't ask all the Kenyans, but you're asking people mainly who have interacted with the judiciary that can you 100% say the judiciary is zero corrupt? So it's somebody's perception. So what I'm saying is it is very unlikely that in our lifetime there will come a time when a survey will be done and the perception, or whether perception or conceived real, because we are telling somebody who lost a case, he could have lost maybe genuinely, but to him there was corruption. So I'm not foreseeing a situation where the percentages as per Transparency International will come to zero, and mainly perception, because here we are talking about somebody who lost his file in the registry, somebody whose case took 10 years to be determined. To him it's corruption. Somebody who had paid cash bail and it took him 2 months to be refunded. He thought that maybe people were asking for him to give kitu kidogo so that he can be paid. To him it's corruption. A title deed maybe was misplaced. He has been waiting for it to be released. To him, if you ask him, he says, these people are corrupt. I've been waiting for my title deed. So unless now we are efficient to the extent that a case is filed today and in 2-3 months it has been dispensed with, that will now reduce that. It won't even eliminate to zero, but that will drastically make us like judiciary. If corruption index is done, we will be at the bottom. I don't know whether there is anybody with zero, any government institution with zero as of now, ever since the surveys have been done. And it's also the nature of our work. So to answer your question, it's the perception.
Thank you. I think I'm glad that is clarified, because I have also looked at some of the surveys that have been done for specific courts, and we do have courts that have zero, that are rated, and I'm hopeful one day even the institution will get to a point where even with the perception, we are rated at zero. Okay, now moving on to the questions that I had for you. I want to read from Article 27 of the Constitution, Article 27, sub-Article 3. Article 27 is basically about equality, and it says women and men have the right to equal treatment, including the right to equal opportunities in political, economic, cultural, and social spheres. And then Article 24, sub-Article 4. The provisions of this chapter on equality shall be qualified to the extent strictly necessary for the application of Muslim law before the Qadi's courts to persons who profess the Muslim religion in matters relating to personal status, marriage, divorce, and inheritance. So in one respect, the Constitution is talking about equality between men and women, and then in another, it is qualified. Why do you think this qualification is necessary? And do you think then, because of that qualification, the Constitution fails to protect certain sections, especially women, from discrimination?
Thank you, Commissioner. To me, the Constitution is properly well intended, and I cannot fault it. And it's also an acknowledgement of diversity many people have that feeling that Muslim women are being discriminated, although I've never seen any Muslim woman protesting that she's being discriminated. Why did the Constitution come in with this? It's like a proviso to a qualification of the equal treatment. Personal status of a Muslim. There is inheritance. It's provided for in the Quran that if I die, my daughter will get 1 share while my son has 2. It's cast in stone. There is nobody who can come and say we want to change it. It has been there for the last 1,400 plus years. So it's the constitutional provision is a realization that whatever we put in the Constitution, we cannot say that it is possible to people, if they come and agree that I've seen it, even in my own family, that we want to share equally. If you agree, that provision will allow you. It's not that, although it's cast in stone when it comes to decision making, if people are disagreeing, but if you agree that let my sister get 1 acre of land and I get 1, you are not going contrary to the religion. So that is one aspect of the qualification, that when it comes to inheritance, and apart from the daughter, even the widow, the share is already provided for. The widower, the share is already provided for. If there are no children who should inherit, it's already provided for. So acknowledging that personal aspect of the Muslim was quite crucial, because it also has a historical perspective. When the state of Kenya was being negotiated, the Muslim community had to be assured that their faith and their personal status will be protected. Then there is the aspect of marriage. If you put in the Constitution that nobody is allowed to marry more than 1 wife, you are infringing on the rights of the Muslims who have the leeway to marry up to 4. I know now we have the Marriage Act, but I think that was a realization that we are a diverse community. So to me, it's not discriminatory, and there is equal treatment in line with the religion.
Thank you very much, Judge, for your opinion. It's your opinion I wanted, and thank you very much for that. Okay, my other question, it is provided in the Judicial Service Code of Conduct that a judge shall disqualify himself or herself in any proceedings in which his or her impartiality might reasonably be questioned. Give 3 instances in which a judge's impartiality may reasonably be questioned.
It comes in many forms. I'll give, for instance, the Court of Appeal, and the same dispute came before me. Maybe I may not have rendered a decision, but I may have in one way or another given some orders in that file, not rendered the final decision. So a party might ask, can you disqualify yourself, Judge? I remember appearing before you. So that is one aspect. Another aspect is maybe the party before you is a relative. You might think that the litigants don't know, but they can say, we have done our research and you are related to the wife of the plaintiff. So you have to disqualify yourself. Then the other forms, maybe you are a member of a certain club which has a case before you. I remember reading judge, I think this is the Pinochet case of the UK, where one of the judges was a member of Amnesty International, which was a party to the case, and the judges had rendered their judgment, but they have had to vacate it because of that. So that personal interrelationship with the litigant, even if it's remote, it calls for recusal, because we say justice must not only be done, but must be seen to be done. So where there is that aspect of not being impartial, then you are called upon to recuse yourself. There are many forms. Maybe it's something which you have dealt with as an advocate. You are an advocate, you acted for a company, and this company has a case before the court. You already have some views on that cooperation. You would rather recuse yourself. And to me, recusal is a good aspect of trying to checkmate the judges and judicial officer. Why should you insist on sitting on a matter where somebody thinks that you should not? There is a difficulty when you are benches, when you sit in benches, you don't make that personal decision. It's made by discussions with the bench, as you saw in the case of Rai, where Justice Tunoi had disqualified himself in the Court of Appeal without any application. But when it came to the Court of Appeal, the Supreme Court, the same request was made, and the bench said, no, because of the doctrine of necessity, we are not allowing you to disqualify yourself. So that is another way of handling the matter. But I think I've given you the parameters. Yes.
Yes, you have, Judge. Thank you. My other question concerns Article 258 of the Constitution, which gives citizens wide-reaching rights and powers to challenge any action that is in contravention of the Constitution. Do you think this right is absolute? And if so, why?
Given to the citizen?
Yes.
To challenge. I can say, since it's already provided in the Constitution, it's absolute, but it should not be abused so that you challenge each and every aspect made. But it is crucial so that there are those who cannot, I think also it's in line with the article, is it 22, which allows anybody to file a petition where there is threat of infringement of constitutional rights. I say it's a crucial provision because it widens up the right to access the court to anybody who can who feels that although this person's rights are being violated, he is a weakling, he may not have the capacity to go to court, let me go to court. I know it can be abused by people who are not interested in the matter other than seeking publicity. But I would say it is important to have it.
Now that you say that it can be abused, do you think then there ought to be limitations to that right?
It will all depend on how somebody will interpret it. If you put, okay, it's a right which can be limited, like you have come and pleaded before me that so-and-so is being held incommunicado without getting in touch with his members of the family, but the members of the family are saying we didn't tell this man to come to court. You just strike out the matter. So limitations can be there, but not preconceived limitations that before you file this matter, because if we put those limitations beforehand, we will be clawing back those rights. So the limitations should be in form of assessment now by the judicial officer, so that you say, although you have come to court, I can't ask you what is your interest. You are saying there is a threat of a right being infringed, but I'm not seeing any threat, and you render yourself like that. But I'm not of the view that we put specific qualification that before any person files a petition relating to rights, he should have such and such interest, something like that.
Okay, thank you, Judge. And finally, what is one truth that you believe in that most people disagree with?
I don't know whether that one can have a specific, because I don't know what, even if we zero in into this room, I don't know what you commissioners believe in. But one truth I believe in the fairness of everybody. That everybody is fair. Maybe you may not believe in that, but I believe all human nature is meant to be good, unless now it exhibits itself in the opposite direction. So there are those who don't. Me, I trust everybody, unless now you make me distrust you. I have that aspect of I meet you the first time. We have never met. I don't have to doubt you. So that is my nature. But as we interact, then I will now see whether you are trustworthy or I should rely on you. So that is I don't. It's a wide question. So I don't think it has a specific answer that I believe everybody should rest on Sunday and others don't believe so, Commissioner.
I got the answer I was looking for, Judge. Thank you. And just to mention, I have received the documents you've subsequently submitted in respect to the wealth declarations that is now updated, and your clearance with the KRA, and yeah, basically those documents. And I think now you are compliant. Thank you very much. I wish you well. Thank you, Chair.
Thank you, Commissioner, and thank you for, in fact, I didn't have that, the information from KRA, but I brought the wealth declaration forms. I worked in the public service. My belief is the documents in the public service don't decay. So they were retrieved from the JSC, and thank to JSC, I got them and I submitted. My wife's were retrieved from the Public Service Commission and I submitted.
Okay. Thank you very much, Commissioner Olwande. Thank you, Honorable Judge. I think you've given us your country and also the visitors, so we'll not get there. Honorable Commissioners, we come to the end of the interview today, and we want to thank you, Judge, for coming back to talk to us. That is out of respect to the process. Unless you have something to tell us.
Thank you, Chair. Maybe I just wanted to refer to the question Justice Majanja asked me. There are any two cases. I remember the community living in the forest is the Ogiek. I think there is the Ogiek case.
The Enderoi.
Okay. And it's good you know my background. I'd come with the intention of clearing one aspect of my life, and I don't know whether it would be prudent, I know, with the time, where the other time the commission asked me, having been charged, what do you think? But if it's not relevant, I don't have to belabor too much on
it. I think we can give you a minute to say what you wanted to say, Judge.
Thank you, Commissioner. You know, sometimes it's good when you have the opportunity to explain yourself. I joined the NSSF in September 2003, and by that time, NSSF had the task of complying with the Retirement Benefits Authority rules. It was skewed towards real estate, so it had to sell its property to reach the percentages required by the law. So by the time I joined, the board had resolved to sell some plots. So I was engaged in the selling of the plot opposite the Grand Regents. Those are 5 separate titles, 4 or 5. They were being sold at cost, 1,370,000,000. I remember they were advertised. A buyer came forth. I think there were 3 buyers, but some did not meet the minimum price. So this is a board which has resolved, and me and the managing trustee were doing the administrative work. So we received the 10% from the buyer, 137 million paid to NSSF. NSSF, not to me. NSSF wanted to be sure that the money is there for the palace. We are talking of 1 billion in 2008. The money was put in the escrow account of both lawyers, NSSF lawyer and the buyer's lawyer. The NSSF lawyer was procured by the board, not by me, because there anything to do with above 1 million, even the managing trustee cannot appoint the advocate. By that time, you had to go to the legal committee and say there is this work. We have these lawyers in our panel, whom do we give accountability? So we had to pay land rates. I went to the lands office myself. It was computed 4 times, 112 million. Tried to negotiate, but it's every time it's computed, because of penalties, it came to that. So I advised my managing trustee, a banker's check was done. I personally went to National Bank, deposited that money. So the transaction went on well. Later on, because the buyer wants to know whether he's buying the correct thing, he sent a surveyor. And it was discovered that the land on the ground is lesser than on the titles. So that's where the problem came in. On the titles, it's 5 acres, but the physical aspect is around 4.5, slightly less by maybe a half or 3/4, like that. So the buyer asked if he could be given a pro rata reduction of the price. A meeting was done and we said no. So the land was transferred to the buyer. On paper, physically had not taken possession. And immediately it's transferred. The lawyer writes to our lawyer saying, I'm ready to release the money in the escrow account, less the pro rata reduction, revisiting the old issue. So NSSF told him no. We had other buyers. I think there was he was asking for less 130 million, something like that. So as the company secretary, we advised, we go to court, we went to court. I'm the one who was advising the lawyer, Mr. Oyatsi, preparing the documents, swearing in affidavits. We got orders to stay any further action. We are also in possession. There is no loss to the land, only the title had passed. I leave NSSF in April 2009. In June 2009, they record a consent in the case. By consent, the buyer has retracted, he takes his money, and NSSF takes its land. The same consent of June 2009 gives NSSF 30 million as costs. So nothing was lost. Come December 2009, you are arrested and you are charged. So that's what I wanted to share. One of the charges is that I conferred benefit to the government, paying the 112 million. But this was money which was demanded. A witness comes and says, I'm the one who did the computation, and without the land rent clearance certificates, we were not going to register this. So that is one count. Another count is paying the lawyer deposit of 5 million in a transaction of 1.5 billion. And it's the board which approves the payments of a deposit. So you are charged for conferring a benefit to the advocate. So I just wanted, maybe people keep on saying there was embezzlement. There was no embezzlement. The money was in an escrow account. If I recollect, it was generating 7 million every month. And nobody removed a shilling from that account. I was not even a signatory to the account. And the owner took his money without a complaint. NSSF retained its land. It's there up to today. So that is just what I wanted to share. You know, some people think that maybe, I remember I had a tenant who refused to pay rent, saying, see the person NSSF. You know, it gives you that negative feeling from other people, but that is what happened, and the record is there for all to see. Thank you for giving me this opportunity. At least I know it's not part of the interview, but I really appreciate it. Thank you, Madam Chair.
Thank you, Honorable Judge, and thank you for that clarification, and also for putting the record straight. And I'm sure the commissioners have had the position, and also the members of the public. So thank you once again, Judge, for coming, and wish you all the best.